So I extend a very, I, Srishti Dixit Soni, on behalf of the organizing committee and Faculty of Law at Mangalayatan University, Jabalpur, welcome all of you to this webinar. I request the head of the department, Dr. Neeraj Prakash Rai, to please address all of us.
Okay. Good day to all of you. I would take this opportunity to welcome our speaker, Professor Dr. Gigimon V.S, Chair Professor, DPIIT, Department of Promotion of Industry and Internal Trade, Ministry of Commerce and Industry, the Government of India, Maharashtra National Law University, Mumbai. I would also like to welcome Professor K.R.S. Sambhasiv Rao, Vice Chancellor, Mangalayatan University, Jabalpur, Madhya Pradesh. Professor Benita Kaur Saluja, Pro Vice Chancellor, Mangalayatan University, Jabalpur. And I warm welcome to all the guests and participants. Sir, welcome. Gigi sir को बहुत बहुत स्वागत है सर आपका मंगलायतन यूनिवर्सिटी की तरफ से। आज का ये जो टॉपिक है ये बहुत ही महत्वपूर्ण टॉपिक है। वर्तमान परिस्थितियों में जहां अधिकारों की होड़ लगी हुई है, वहां यदि हम इंटेलेक्चुअल प्रॉपर्टी राइट की बात करें तो ये टॉपिक मल्टी डिसिप्लिनरी टाइप का टॉपिक है जो हर डिपार्टमेंट के लिए बड़ा महत्वपूर्ण है। तो इस महत्वपूर्ण टॉपिक पर टॉक करने के लिए सर हम बहुत बहुत आभार व्यक्त करते हैं और आपका स्वागत करते हैं। मैं रिक्वेस्ट करना चाहूंगा माननीय वीसी सर से कि सर काइंडली ग्रांट अस द परमिशन टू स्टार्ट द इवेंट।
My permission is not required. Namaskar, sir. It's permission is not required. It's no, welcome the guests, and you can start the program. It's
okay. Thank you, sir. So proceed, the Srishti ma'am.
Thank you, sir. Before introducing our guest, I would like to inform everyone that if you have any questions to the speaker, then you can put your question, just type it in the chat box. You don't have to use your mic, just type it in the chat box. And secondly, the link for the certificates would be shared shortly. Okay. So without much further ado, I would like to introduce our esteemed guest today, Professor Dr. Gigimon V.S. Sir is the Chair Professor at Department for Promotion of Industries and Internal Trade within the Ministry of Commerce and Industry, Government of India at Maharashtra National Law University, Mumbai. He has done BAL and LLB from Kerala University, LLM from Hidayatullah National Law University, Raipur, and PhD in Law from CNLU, Patna. He has more than 2 decades of teaching, research, and practicing experience as an associate professor. He was also the head of department at Mar Gregorius College of Law. He was also the founding head of the department at Dharmashastra National Law University, Jabalpur. He has been associated with various institutions, prestigious institutions like RGNLU Patiala, Christ University Bangalore, NLSIU Bangalore. He was also the registrar of Bar Council of Kerala, M.K. Nambiar Academy for Continuing Legal Education in Kochi. He was the chair coordinator of the Professor Madhav Menon Chair on Legal Education. He was an expert member of the Legal Education Committee of the UGC on Transforming Legal Education. Currently, he is also the Joint Secretary of Association Asia, India chapter, and also of Menon Institute of Legal Advocacy Training, Trivandrum. He is a member of several organizations such as Global Alliance for Justice Education in USA, and many more. I would go on, and yet my words would not be able to do complete justice to his expertise and contribution to the fields of law and legal education. Sir, I extend a very warm welcome to you. Please address this webinar as we all are eagerly waiting for your valuable insights on this subject. Over to you, sir, now.
Thank you, Srishti, madam. Honorable Vice Chancellor, Professor Dr. Rajasurya, the Head of the Department, Professor Dr. Neeraj, sir, other officers of the university, my friends who have joined for the session, and dear students. As rightly pointed out in the first talk itself by the HOD, that this topic is very important as far as the regime is concerned, because we are now moving into a technology-based life, to be very precise, because the technology is overtaking in us in every sphere of life. So the creations that we are now doing also is now, as a students, you may be more knowing that how much we depend upon all the AI-based technology systems for many of our creations, including the reels that you make, as well as the projects that you submit to the universities. So the technology has moved fast ahead, but our laws, did it move that fast? That is one of the questions that comes into picture when we analyze the technology versus law. And even if you look at the penal laws or any other general laws that is concerned in India, most of them are now in conflict with many of the issues with regard to the technology. The laws are not able to combat the issues that the technology is posing out to us. So in those regime, now the intellectual property law, which is also one of the very important aspects with regard to the development of the country is concerned, because technological developments, the creations, everything has a lot of the economical impact also. So in those regime, we are looking at a particular area of study where there is lot many challenges which are going to be coming up as we haven't advanced our legal system to that, but to cope up with these challenges, including we normally depend upon most of our legal developments are normally depend upon the international arena. Even in the international arena, this is facing a big challenge and big issues with regard to many of the advancements are concerned. Now, I'll be sharing my screen now so that I can start my presentation with regard to the topic is concerned. I hope the screen is visible.
Yes, sir. It is visible, sir.
Yes, thank you, sir. So, as the topic itself suggests, this is something called as legal challenges to copyright protection in the generative artificial intelligence era. Now, as I said in the very first, that there is a lot of creations that are happening with the use of technology, that is machine creation that we call. And it even starts, if you can analyze the machine creation, this also starts not only with regard to this the creation that the chat GPT is doing, but also to the advancement of the biotechnological regime, as well as many other concerns. Now, while accessing the readings with regard to the AI creations or the machine creations, even I came across, there have been so many creations of clinical, the molecular, the machine invented molecules which have been going up, which have been facing now the clinical trials in the human being also. So this has traveled a lot, and the AI's deployment has reached almost every sector of life that we come across. Now, whether we take it is concerned the industries, or it is concerning the protection of state or country is concerned, or even with regard to the social media issues are also concerned. Now, when we look at the AI and copyright issue, there are certain violations that we normally come across. While we going through the further, I'll be deliberating on these issues majorly, because one such issue is with regard to the data integrity. Then comes the issue of the creativity. Who is supposed to be the person who could be made liable for a violation of copyright or any other or violation or any legal implications. And then comes the issue with regard to privacy, which is one of the major concerns now we are facing in this era when it comes to any posting with regard to social media is concerned. Then the issues like this, there are so many small issues which are associated with this concern with regard to the AI is concerned. Now, when you look at the intellectual property rights, or the term called as IPR, I'll prefer to call it as IPR in short. The IPR is concerned now. This protection is totally with regard to the creation and creativity, and this is something called as a intellectual rights. I mean, a creation that has been created by a person who has used his intellectual property for the purpose of the creation is concerned. Now, the reason for recognizing or giving a right as an intellectual property is concerned is for the purpose of monetizing or creating an economical value for somebody's idea or somebody's creation or somebody's development with regard to that creation is concerned. So this is something which we could associate always with what we call as the intellect of a person, wherein the rights will be protected. That is what the complete law of intellectual property is concerned. As been put up in the slide, it encompasses various legal rights protecting intellectual creations, including copyright, patent, trademark, and trade secrets. And it also promotes the people to go for further investigation. As you might be knowing that every time why we are coming out with much more products that is available in the market, which has been an upgradation version of an older product. That is because the innovations or the recognition to the innovations are happening then all the time. And there's also a lot of economic value that can be associated to IP research. So why I'm saying a value of, because the intellectual property asset management is one of the area where this particular economic value can be assessed and commercialized by them. Because now you see that in India there are many intellectual property protections being given to. So there are a lot of many licenses, many people, but the actual economic value of those is never ever ascertained in the countries now concerned. And there are many frameworks are concerned with regard to international like TRIPS agreement or the WIPO treaties or other conventions which are internationally governing this. And as I said, this is concerns with patent, trademark, trade secrets, many included in this concept of intellectual property rights concern. Now, while coming to the major area of today's discussion is one is the copyright protection. Now, what do you mean by copyright protection? Now, it is an exclusive right granted to a particular person, the creator of the right, to reproduce, distribute, perform, and display their own original works. Now, as I said, it's an exclusive right. Now, this is something which is given as a right which a particular person gains automatically. Then he need not have to normally go for registering that particular rights. That's because it is the creative work. Suppose you look at the cinematography as one of the creative work. Now it is automatically protected the moment it gets certified and it is released out, right? And nobody can take over those rights which the producer has with regard to a film or a performance with regard to a particular movie or anything is concerned. So now the copyright protection is also given for a particular period of time, that is the creator's lifetime plus 70 years. So this is the complete protection with regard to the duration of the particular rights is concerned. Now, If there is an infringement, you have to approach for the courts for the purpose of getting the legal remedies with regard to that is concerned. Now, generative AI and the copyright. Now, this is the core issue with regard to the copyright is concerned. Now, there are certain questions that are put forth in the slides with regard to AI and copyright is concerned. Now, in the world where machines and software can surpass human intelligence, challenging traditional views, why should the creation of advanced AI be not been entitled to the same right as human generative intellectual property? Now, as I said in the very first beginning, the copyright is normally given to the author or the creator who creates that. Now, if we utilize the purpose for the creation of it, the machine, so who has the right over it? This is one of the major issue or question that has always been discussed and debated in world over, because we haven't made any regulation with regard to the AI and copyright is concerned. And India is also one of the country which was also facing this particular issue. When we go further in the slides, we will come across the case studies wherein I'll be discussing about this. Why differentiate between AI and human generated intellectual property? Now, this is the other issue that has come across in the topic. In the I create a machine which makes another product. So why shouldn't I be given the rights with regard to that particular machine made product is concerned? So that is one of the major other question that we'll be looking for in the complete discussion. Then should the creator of the advanced AI or AI itself be denied ownership? Now, this is one other issue that we'll be discussing in the one of the case laws, whether the AI gets the right or the author gets the right. Is it or is a combined right which has to be given? Now, these are the areas which we'll be looking for in the next few areas of discussion. Now, according to Indian Copyright Act, Section 2D, which defines the author to include in relation to a literary work, dramatic, music, or artistic work that is computer generated, the person who causes the work to be created. Now, it is very clear that it goes straight away to the author who creates any such kind of work, which is a literary work or a dramatic or a musical or artistic work, or that is computer generated. The person who causes the work to be created is the author of it. Now, that means the author gets the rights over it. Now, before going further into it, let me put out this particular question with regard to the authorship is concerned. Now, there have been issue with regard to the authorship. As I said in the definition, says the author creates it. Now, there have been issues that I have mentioned was with regard to when it comes to machine created work that is computer generated, the person who causes the work to be created is the author. You have to understand the person who causes the work, even if the work that is computer generated. Now we move to the next part of it. Now this is one of the issue that has come up. This is called as the next redundant. If people, I don't know how many of you know about this. The redundant was one of the artists who creates, who paints using his styles, his technology, his what do you call it? Whenever you analyze a painting, we analyze it on the basis of the best the point in which he draws, or a point in which he paints, or he uses the brushes that he used for painting and the strokes that he makes with regard to that. Now, when this is been created by a painter or a person who paints it, his style or his methodology is what is the unique form of it. Now, if I use a AI methodology for analyzing all the paintings that a particular painter creates and understands this stroke of it, to understand the minute details of it, and if I create something, a new painting, which is supposed to be the creation that the painter has not been done. So in that circumstances, what is the complete rights of this particular painting is concerned. This is one of the questions that have come out in this particular the issue of 3D painting, which was created called as the next Rembrandt. Rembrandt was a very famous painter who, I mean, renowned Dutch painter who was in the 17th century. Now, you know the value that has been attached to a Rembrandt painting. So now, if an AI creates a new Rembrandt painting, what happens to this? Right? Who gets the? Can it be considered to be as a violation, or can it be considered to be as a problem with regard to the copyright concern? So this is one such issue wherein the discussion point starts with regard to the use of generative AI and the copyright is concerned. I mean, I know I'm going on speaking, but I can also put forth, if any questions comes in, you can stop me and raise the questions in between, or you can send it in the chat also. Now, analyzing this, I would like to know what is the view that the listeners are taking up, because there has to be some contradiction to this also, because analyzing the work, suppose if a person that, I also put forth this with my students also. There are many musics available in the open AI, open data, that is what called as in the internet. We get lot many musics available, and I download all the musics and I put in a machine which creates a new music for us. Now, what is there any problem with regard to copyright is concerned? This is one of the issue that is to be answered now. Now, there is another issue with regard to copyright, is case study with regard to copyright is concerned, that is governing the concept called as DABUS, which is a device for autonomous bootstrapping of unified centers. Now, if you analyze this as another case study, now DABUS is something which is an artificial intelligence system created by one Mr. Stephen Thaler. Now, this is a food container product. This is a food container product which enables rapid reheating, and if there is any problem with regard to that is concerned, there's an emergency which could indicate with regard to what is the problem with regard to. Now, the patent application for designing this as an invention has put up a question with regard to whether the AI system can be granted a patent with regard to intellectual property concern. Now, that is also one of the issue wherein the court also looked into the granting of patent to AI concern. Now, in this was an issue wherein the South African Intellectual Property Commission granted the patent to the Stephen for the purpose of this particular product. So now, this is another area wherein the issue of AI comes in, and the court took a very lenient view by granting the patent for this particular product. Now, I don't know how many of you are aware of with regard to this case is concerned. This is Mr. Raghav, who is one of the author. Mr. Raghav, who has created an painting, which is an AI-based painting. And he's an AI-based painting. Am I audible?
Yes, sir.
Yes, sir.
There's some glitch. Now,
No,
I
sir,
was
you're
discussing
perfectly
about
audible.
an issue with, or a similar kind of an issue with regard to the the copyright wherein the Indian case study is involved. Now, as I said, Raghav is the name wherein an AI based, wherein a creation which was made by an AI based thing for a painting, which was named as Raghav. Now, Mr. Raghav actually uh, was given to the AI because the patent application, sorry, the application when it came to with regard to these rights are concerned was put up before the government office. The government office, the copyright office did not recognize it in the initial stating that the copyright can only be given to the author who is a human. Now, then the issue came in that whether it can be given to human or it can be given to AI also. Now, as an innovative thing, later on, the government, the Copyright Office recognized his first creation, stating that this is something uniqueness which we are going to recognize. Now, later on, when the objections started to come, the recognition was stopped. Recognition was stopped, or the recognition was revoked by the Copyright Office. Thereafter, the applicant made an correction to the application and added the creator's name, which is Mr. Ankit, and his name also, and made as a co-author, and copyright protection was again put up before the. Then subsequently, the Corporate Office mistakenly granted the registration, but later again issued a notice recognizing that this is also not possible under the law. Now, here the question comes, can the authorship with regard to a copyright protected, if it is a machine created as well as a human jointly giving it, can it be given jointly? Or if it's a machine created, the machine cannot be given, can it only be given to author? These were the two issues that need to be answered with regard to AI is concerned. It is very clear that nowadays we do not have any regulations with regard to this. It's only that the law is very silent on this particular part of the copyright is concerned. Now here, there are certain questions to be understood. What is the legal status of Mr. Ankit Sahni with regard to the AI system is concerned, that is copyright is concerned, whether it can be given or it can be not be given, whether it can be withdrawn. Now, to understand that, we need to look into one few more things are concerned. That is, now while creating the AI based machine or generative AI for the purpose of creating a new product or a data analysis concept or anything with regard to that is concerned, you also have to look into the background of this. From where did Mr. Where did this AI got the data from? Now, there is some pertinent issues with regard to that. Now, one particular issue, that is there's free flow of data in the world is concerned. Now, you do not have anything which regulates the data in India is concerned. Now, recently we have come out with the data protection law, but what happens to this data? Whether this data which has been taken by the AI, is it privacy protected? That is one issue that you also have to look into. That means whether there is a violation of privacy with regard to what data has been taken up by the AI. Second issue that also comes in is whether the data which has been taken, is it copyright protected? Now, when we Google out, we may get lot many documents with regard to a particular topic is concerned. If it's AI or is it copyright, we have so many data available in now. Now, when we use any AI methodology like ChatGPT or any other open AI sources for the purpose of creation of a project or a subject, a topic is concerned. Now, is this protected data which has been used by AI for the creation? In that circumstances, you are also the outcome product which is coming out is also a copyright violated thing. Okay. Now, if we are using a database which is been available in this open source and which is in violation of privacy, suppose we never know from where we get the data. So there are a lot of places from where you can get easily access or download protected data also. So if a creation which has been created which violates the privacy policy of the data which has been given in, that is also one concern, and the outcome which comes out cannot be given that particular right of the data. The outcome that comes out will not get the rights are the concerned rights are concerned. Then there is also, as I said, with regard to one major issue that is been now happening in India is one about the deep fake issues which is now running in. Now, so, recently I came across a document wherein there was an issue which was coming up and discussed. That is with regard to the rights of a performer whose creativity has been done based on a AI model preparation. That means the voice, the acting, the style of his performance has been adopted from a AI generated model. There is no actual actor involved. There is no actual actor's voice involved. There is no actual actor's style involved. If I can give an example, suppose we create a AI model based performance of Mr. Shah Rukh Khan without he being involved into it. Now, in this circumstance, is there a violation of it? This is also one of the pertinent issues that has come across in discussion in the latest stages, wherein where I said that is what I said, the fake issues are concerned. Now, all these are the pertinent issues which connects the AI with regard to copyright is concerned. Now, this current situation which I mentioned with regard to Raghav is concerned, the Copyright Office website still says that it is registered in his name. Now, the Raghav and Sahani as a co-author have created a copyright painting which is still there as a right recognized. But as far as the information that is coming out was the Copyright Office have withdrawn their rights or their license given to them. Then the court's decision, now if this case comes before the court, what will be the court's decision will come or will be a major point to be discussed, to be traced down discussion with regard to the copyright of AI protected data is concerned. And that will come out to be one of the new law with regard to the copyright of AI protected things are concerned. Now, this is one of the landmark judgment with regard to the AI and created artwork. That is Stephen Thaler versus which I discussed in the first. Now, the US court made a landmark judgment by giving recognition regarding copyright registration to artwork created by a machine. Mr. Stephen Thaler, who was the owner of the creative machine, has requested for this copyright, and the Copyright Office rejected the claim. As I said, the legal battle was specifically with regard to the consideration that copyright requires human authorship. Now, the court in the US has come and has interpreted the Copyright Act and has included that the Copyright Act requires the originator to be a human being for the purpose of copyright eligibility. Now, this I have discussed in the first, so that whether there is a need for a human or there is only machine created thing. Now, as discussed and deliberated with regard to this is concerned, the machine is a creation of the human being. So there is also a role that a human also plays in with regard to machine creation is concerned. In the conclusion, the court very clearly and very giving a justification to the case, has said that the AI generated work created by creative machinery was never eligible for copyright, upholding decision to deny the copyright registration for the work created without the human involvement. Now, here again, the question again that is being deliberated was, now the machine which has been created is created by, if suppose without involving any data infringement or privacy infringement or violation of a copyright or anything is concerned. In that circumstances, can this be given? This is one of the other question which again comes out to be a discussion point. Now, what are the challenges that has been put forth with regard to the current copyright law regime and the generation of AI is concerned? Now, we have many issues with regard to the ambiguous authorship, because determining the author with regard to AI generated is very big challenge. As I said, where there is a copyright violation, if we grant a copyright to a AI generated which has been a violated thing, then the issue comes in. Then fair use dilemma. Now, defining originality for AI generated work and navigating the complexity of fair use has becoming a very big challenge with regard to the copyright issues. Now, fair use is a big issue generally also with regard to the copyright issues as concerned, because there have been so many judgments wherein the court has defined what is fair use, and every then and now the term of fair use has been elaborated by the court by adding new dimensions to it. So now again, if the AI generated works comes in, what could be the concept of fair use? Now, in an academic institution, when we distribute materials for the purpose of reading to the students, which is a copyright material, now that can be considered to be as a fair use because it is only circulated in a private, wherein we are not looking at any commercialization. But what happens if there is a commercialization coming? Therein the fair use concept also changes. That's how the issue of fair use comes in. Then the issue of human intervention and ownership uncertainty. The requirement of human authorship in copyright law has a conflict with the AI-based team, and raising uncertainty about the ownership control, particularly in collaborative AI projects, is one big issue, wherein the ownership issue is also a problem with regard to copyright concern. Then global harmonization and legal liability. Now, lack of international. This is one area which I also have raised an issue in the very first, that the internationally, how will we recognize this concept of copyright, wherein what poses to be a very difficult issue, but copyright laws varies globally, and a change in a copyright law in a country, as we do not have anything what is called as a internationally acclaimed or recognized concept with regard to the AI-based copyright laws is concerned. So there is a issue wherein one country there will be a protection and the other country there could be a violation. So that is also one of the big or major issue with regard to the law is concerned. And then adaptation of legal framework and ethical consideration. Now, the existing the law may lack flexibility to address the change that is happening right now. And as I said, there are a lot of ethical concerns with regard to the copyright is concerned. Now, as I mentioned in the discussion, that what happens if we violate somebody else's right and create our own thing, our own document, which we get copyright protection? There is also this issue which we may face in the what we call as ethics part of the research is concerned, wherein I said collaborative research projects with AI, wherein the ethics issues also comes in out as one of the issues that we also have to look into. Now, these are some of the major major areas wherein the copyright issue comes. Now, I'll conclude with one more further example of the Amazon Audible litigation that happened in US, wherein the I don't know how many of you use this Amazon app called as for the purpose of audio posts and other things, wherein the audio that you hear generates the auto captions. Now, AI is the methodology that has been used for the purpose of generating the auto captions. Now, when the auto captions or the summary of these are being created, whether this violates the copyright is one of the major issue that came out in this particular case. And this is also a decision wherein the authors challenged the Amazon's Audible product. Now, the summarization definitely looks to violate the rights which has been granted to the copyright owners. So in this also the court said that it's a violation. So again, I said this complexity of looking into whether there is a violation of the copyright goes on to on case-to-case basis. When you analyze the 4 cases that we discussed, every case there is a different opinion being taken up by the copyright authority or the court is concerned. As far as India is concerned, we are still waiting for a decision from the courts with regard to the AI-based copyright violation things are concerned. I hope I was able to give out a brief discussion on this topic is concerned, because as far as this topic is concerned, it's something which we need to discuss and deliberate and come out with new laws or new regulations are concerned. So in the future, we may come out with some regulations. In the future, we come out with some regulations which may discuss this particular point, and we may have further deliberation on whether this protection which has been granted is correct or to be reworked or re-looked upon to. So, and with this, I conclude, and I am open to certain questions if there is anything. And
Yes, sir.
yes.
So there are a few questions from a few students. Snehal has asked, can you copyright what an artificial intelligence model creates? Which I think you have covered here.
Yeah.
Would you like to elaborate?
That's precisely when we look at the outcome of the product. As I said, the law is not yet clear on this particular point, whether to give protection. Some countries like in China, they have the China Provisional Court Beijing Provisional Court have given protection to the AI-based AI-based products are concerned without the author being. Now, why this is a issue is that the intellectual property is what is to be protected. Now, machine property, can we start protecting it under the law is concerned? That is what one of the concern coming out to be. Yes, Srishti.
So there is one more question from Shiril. How can existing copyright laws adapt to address the challenges given by generative AI with respect to issues like authorship?
Yeah. Now, the existing law. Now, one point with regard to authorship is concerned. Suppose if it's a novel or write-up or anything that has been created by the AI. Now, the product that is the outcome of a generative AI model, if it so defines that there is no violation of any privacy or any authorship or anything is concerned, if it is to be proved and amended, and with the amendments of the law is concerned with regard to the as we have in patent, we actually analyze the complete work is concerned. So if we like the same way, the copyright protection will come in only place wherein we be able to analyze the complete outcome is concerned. If we can analyze that and there is no violation being found in the outcome of the product is concerned, then in that circumstance, as I said, the author can be given, because author can, suppose it's a modified work which comes out after the AI generation. Suppose AI generated an A piece of work which has been modified by the intellect of the author and reworked upon, and the product B comes out. That could be one which can be protected as on date. Now, if the author wants to also protect if the AI generated one, therein the issue of the analysis of whether the violation, if there is a violation, if there is any legal implications, if there is any problem which has been coming, if there is no what do you call it, objection to be put forth by any of the people, in those circumstances the product can be protected, and that will happen only after the amendment to the law is concerned, because I said this requires a lot many deliberations to what are the categories of things which could be protected concerned. So therein only this change will happen. Then only we can go ahead coming out with a amendment to the law and protecting the work is concerned.
So one last question, a very interesting question from Subhashish. Does using paraphrasing apps or tools amount to plagiarism?
This is one big challenge the education institutions face, the paraphrasing of the app. I mean, using the paraphrasing app for the purpose of paraphrasing the work that you do. Now, it is if it's only the checking of the grammar is concerned. I mean, I would as a teacher, I would say that we are not perfect in working with regard to the grammars is concerned, because as lawyers we may sometimes tend to miss out the grammatic. In checking the grammar is concerned and paraphrasing is concerned, it's okay. But the copying of the idea and re-paraphrasing it into so that it doesn't violate the copyright of the author who has created this is something where is the violation. That is a clear violation with regard to law is concerned. And generally, as teachers, Ashish might be, as generally as a teachers, Ashish might be knowing that the teachers are very clever with regard to understanding when you paraphrase and re-paraphrase the work which has been copyright protected.
So one student, Yash Bhatia, wants to know the privacy and security concerns associated with AI, specifically in legal industry.
Legal industry, I mean, do you specific on what in the legal industry are you specific? Now, I can give you one example. Now, suppose if you are looking at drafting a petition on a particular point of issue, therein is concerned, no, there could not be. Now, suppose there is the draft of the contract, which is available or created by AI is concerned. So those are some documents which are general in concern. So therein, I don't think there is any copyright violation, or you could look into, because that is something called as a generic mode, which has been, I mean, a draft of a contract or a draft of a petition or a draft, those are concerned. As far as legal research is concerned, yes, in those things, again, the copyright issue will come, suppose if you are violating or if you're copying something which is somebody else's idea is concerned. Other than that, I don't think drafting petitions or drafting decisions will never come into the issue of copyright. Or maybe you may be looking at a point of view wherein the AI is coming to judge as a judge with regard to a dispute is concerned. In those circumstances also, it's only a dispute resolution mechanism that we are adopting into. So therein, I don't think such kind of an issue can come into.
I think there is no question. I would like to conclude this webinar.
Yeah, ma'am, before I conclude, let me also thank each and every one of you for giving me an opportunity for being part of this particular seminar, and specifically to Srishti ma'am, who was my former colleague in Jabalpur. She's a very hardworking teacher and very cooperative in working, and we had a very good time in Jabalpur as a teacher, as a colleague. And also thank the HOD, Professor Neeraj sir, that we look forward to further such kind of programs, because we as a chair, we organize lot many AI program, the IP programs where new technology, new advancements, discussions, everything happens in we also are having a seminar coming up, an international seminar coming up in the next month, December 9th and 10th, where we are looking at AI and IPR as one of the AI and IPR is a topic for the seminar. So the discussion point we are looking forward to further take and come outcome of that particular program. And also today in the afternoon, we are starting a program, a capacity building program on AI and outer space, sorry, IPR and outer space, when IP issues with regard to outer space is also discussed. It's a capacity building program for 15 hours, wherein participants are students and various policyholders, even the international participants are also there. And it's also one wonderful program that we normally organize. And as a chair, we involved into institutions and do joint programs for them also. So in the future, probably I would definitely like to collaborate with Mangalayatan University Law School so that some new programs can also be planned into. And thank you for
Sure.
inviting me for that.
Sir, on behalf of
Thank you.
Department of
Thank you
Law,
very much,
I would
sir.
like to propose heartfelt thanks to our speaker, Professor Dr. Gigimon V.S., for gracing today's webinar. Sir rightly stressed and talked about the intellectual property right, copyright protection, backward skills, and challenges to current copyright, and much more. Thank you, sir, for sharing knowledge with us. The insightful presentation was truly thought-provoking, and I believe we all have gained valuable insights. I would like to express our profound gratitude to our Honorable Vice Chancellor, Professor Dr. K.R.S. Sambasiva Rao, sir, for his presence in this webinar. Thanks to all respected professor, colleagues, and all the participants who have turned up in such a great number. Once again, I thank all for your support. Thank you so much, sir.
Thank you all.
Thank you,
Thank
sir.
you so much.
Sir.